Thank you. Thank you. Hello, I'm Jason.
And I'm Justin.
Yeah,
Good morning.
So, thank you guys for hanging in there with us. This is the last concurrent session, and I've seen a lot of really good classes. Been able to attend the conference and seen a lot of really good classes. But I want to tell you three things, or I want to start out with three things as far as establishing our expectations for the class. Number one, we do not have any funny YouTube videos in this presentation. Number two, I do not have smiley face stress balls to give you after this class as a prize. And number three, and this may change your mind, you may want to bail after this, but I do not have a pocket full of chocolate to chuck at you if you ask a question. So just want to get that out in the open to start out with, make sure that we've got our expectations right. We've got 15 slides we're going to go over today, but we're basically going to talk to you about a lot of different things. We have a presentation that's in the resource section of the website that's about 75 slides, 72, 73 slides.
71?
71 slides. That's more of a narrative. So when you get back home, pull that up and read it. That'll help you take away things, because we're going to go at a pretty good pace, and you don't want to write things down, but everything's in the narrative that should be able to help you later on when you get back home.
Should have all your case citations and everything like that in the fuller expanded version of the PowerPoint online. So just a quick note about what we're going to cover today. You can see here we have a pretty aggressive agenda that we're going to try to get through. If we don't get through it, we like I said, it's all online. So don't worry, it's not gone forever. But that being said, just a quick note. Knowing this is a national conference, you guys are from everywhere. I've met people from places I've never met people before this week. So we tried to focus on either U.S. Supreme Court cases, so they're going to apply to everyone, or to federal employment laws that are also going to be applicable to everyone. So didn't get in the weeds on this circuit said this circuit said this, on that kind of case law, but we're going to try to hit the national highlights of coverage. So as you can see, we're going to start out with talking about some recent Supreme Court decisions, and then we'll move into LGBT employees and certain issues surrounding them. Then the NLRB, social media and employee handbooks. We were discussing before most everyone came in. The NLRB is probably one of the first entities that's trying to take a grab at having a say on social media policies. So we're going to discuss that briefly. We're going to hit the EEOC and Strategic Enforcement Plan. That's their strategic enforcement plan for fiscal years 2013 to 2016. So still have some coverage left on that. And as we'll discuss, even after fiscal year 2016, I doubt they're going to let those things go. So then we're going to end on the ADAAA, the Americans with Disabilities Act Amendments, or Amendments Act, sorry. Now that's not exactly new for a legal update. That became effective in 2009. But what we've seen are a lot of people have taken no action in response to that. So want to make sure we at least hit that everyone's aware of. So without further ado, I think we should get started. First case we're going to discuss today is Young versus UPS. That's regarding the Pregnancy Discrimination Act. In short, the facts are female part-time delivery driver for UPS became pregnant. Her doctor issued a lifting restriction for her of less than 20 pounds. UPS required all of its workers to be able to lift at least 70 pounds. And so Ms. Young requested light duty. She was unable to lift that 70 pounds. UPS denied her request and said that they only offer light duty if you've been injured on the job, if you are considered disabled under the ADA, or you lost your Department of Transportation certifications. And so Ms. Young unfortunately stayed home for the duration of her pregnancy without pay, and then sued for pregnancy discrimination for failure to accommodate.
So the issue at hand here is whether an employer who accommodates a large percentage of non-pregnant workers violates the Pregnancy Discrimination Act if it fails to accommodate a large percentage of non-pregnant workers. So basically, by a show of hands, do you think, is the employer required to accommodate under pregnancy discrimination? Can you raise your hand if you think UPS was? Okay. How many of you guys think not? How many of you guys think UPS did the right thing? Wow. We've got a smart audience.
Yeah, good deal. You all are correct. The Supreme Court held that an employer may, now again, that's a may, as with anything in the law, may violate the Pregnancy Discrimination Act if it accommodates a large percentage of non-pregnant workers, but refuses or fails to accommodate a large percentage of pregnant workers. So basically what it all comes down to, employers must treat women affected by pregnancy the same for all employment-related purposes as other persons not so affected, so not pregnant, but similarly situated. Male truck driver unable to lift because he has a herniated disc. They're going to accommodate all of them. They need to accommodate their pregnant workers who also have lifting restrictions.
I think organizations get in trouble when they build rigid or inflexible policies and then say we have a policy, we've used this policy 20 years, there's no way we can do that, we just don't do it. I think that's where your organization kind of gets in a trouble zone there. And I think you've got to keep an open mind and look at your situation. And I think you'll hear Justin and I talk a lot today about individualized assessments and interactive processes and things of that nature. So from an organizational perspective, be careful about these policies that you follow for 25 years. You want to kind of take a look at those, brush off the dust on them and look at them. When you talk about UPS, their big policy was what? 3 reasons we accommodate, right? We say ADA, on-the-job injury, or if you've lost your DOT certification. So they kind of stood behind that, but they probably should open their mind a little bit in that case.
And one thing I'll say, I'll go ahead and tip the reveal at the end of the session when we get to the EEOC Strategic Enforcement Plan. The Pregnancy Discrimination Act is something that the EEOC is putting as one of their 6 national priorities. I would recommend that everyone take a look at your accommodation policies and dust off a copy of the Pregnancy Discrimination Act and take a look at that if you haven't done so in a while. Any questions on that? I don't think we mentioned at the beginning, like I said, we have a pretty aggressive schedule, so we're going to try to go straight through, but if anybody has any questions, feel free to interrupt. We welcome your guys' interaction. So anything? Okay. Moving on to Integrity Staffing Solutions v. Busk. This case involved the Fair Labor Standards Act. You may remember this case as the Amazon worker case. Basically, the short of it is Amazon fulfillment center workers. Basically, these are the people who walk around with the orders, huge stacks, looks like the Indiana Jones warehouse, pull off the right box, put it in a tote all day long. Pick product all day. These employees were required to stand in airport-style security screenings for roughly 20 to 25 minutes when they're leaving work every day. Apparently Amazon had a theft problem or feared it was going to have a theft problem, someone tucking iPads in their coat pocket. So these employees sued the Integrity Staffing Solutions, charging that should have been compensable time. They should have been paid. That time they spent in the security screening, before they could leave work, they were off the clock. They had clocked out. Then they're standing there for 20, 25, 30 minutes. They argued this was only to the benefit of the employer. This is not, you're requiring us to do this. We don't want to do this, so you should pay us for this. So
the issue in the case is whether the time employees spend waiting to undergo security screenings is compensable under FMLA. So I'm going to throw it back to you guys. Do you have to pay employees while they wait in security lines before they work? Who thinks you do? Raise your hand. Okay. Who thinks you do not?
Looks like
pretty even. It's about 50. It's kind of 50-50 a little bit on that one. Yeah.
Looks like we got one side of the room versus the other, and I will say these guys got it on this one. Something called the Portal to Portal Act. It's a federal law. It basically talks about that employers only need to pay employees for the principal activities of their job. So any activities that are preliminary before work or post-preliminary after work that are not principal activities are not compensable under the FLSA. So in this case, the principal activities of these employees' jobs, like we said, was to walk around and pick products off the shelves and put them in totes. The principal activity was not to stand in the security line. And it's important to note that even though this was only for the benefit of the employer, or even if it was for the employee's protection. So what does that sound like to you guys? A bunch of court employees? Security screenings, right? I think that's going to be your takeaway here. Hopefully you're not having any of your employees challenging or suing you about being paid for waiting in security lines, waiting through the magnetron. But this case would be relevant to that issue if that comes up.
Any questions on that case? Okay, moving on.
Okay, this case, bear with me on this one. This one's not that exciting of a case. I'll just put that up front. It's a very technical, legal issue here, but it involves the EEOC and them being able to sue an employer for a violation of Title VII. Everyone knows what the EEOC is? Yes, good. Basically, they enforce Title VII of the Civil Rights Act. So this case, basically the EEOC investigated Mock Mining, the employer. They determined that there was reasonable cause that the company had engaged in unlawful hiring practices, and they decided they wanted to sue the employer. Now, you may not know, you may know, the EEOC is required before they can directly sue an employer on behalf of an employee. They're required to engage in conciliation efforts with the employer, basically try to resolve it amicably, resolve it informally before going to federal court. So here was the EEOC's conciliation efforts in this case. They sent a letter saying, they sent a letter inviting the employer and the charging party to participate in informal conciliation, notifying them that an EEOC representative would contact them.
That was it?
No, there is one more.
Is there one more?
I'm waiting, because then they waited a year. They waited 12 months. Mock Mining never heard anything from the EEOC. A year later, the EEOC sends them another letter stating that conciliation had been unsuccessful. So that was the sum total of what the EEOC did in that case for conciliation, and then took them to federal court. So the issue here, and like I said, this is not a very exciting case, but the issue was then whether courts have the ability to review the EEOC's conciliation efforts before they can go to court, before they can sue.
Right. So how many of you guys think that the courts can review the EEOC's effort before the lawsuit? Raise your hand if you think that courts can review the EEOC's efforts. All right. How many of you guys think no? Again, very smart group.
I agree with you guys. Of course, the EEOC disagreed with all of us. The EEOC didn't believe that courts had any authority to review their conciliation efforts. EEOC lost that argument, but I will say this is somewhat of a hollow victory for employers. The court did rule that the EEOC's conciliation efforts can be reviewed, but then it clearly stated that EEOC only has to do 3 simple things in conciliation. Inform the employer about the specific discrimination allegation, describe what they've done and which employees or class of employees have been affected or suffered, and then try to engage the employer in discussion to give the employer a chance to remedy the allegedly discriminatory practice. That's it. They don't have to actually, so the amount of good faith that's involved there, questionable, or that's required is questionable. And the court didn't even get into that issue in this case. So kind of a hollow victory, but there is something. So the EEOC can't just send you a letter, 2 letters a year apart, and then take you to court. But what process you're going to get, what informal process you're going to get is probably going to be limited if you find yourself in that unfortunate situation. Any questions about this one? Like I said, that one's kind of a little obscure, kind of technical. Okay, moving on to EEOC v. Abercrombie & Fitch stores. Everyone knows that brand, I assume. This case was regarding religious discrimination. The facts of this case, the job candidate, and forgive me, I'm not sure if I'm pronouncing her name correctly, it's Samantha, I think, Eloff. It is a practicing Muslim, and she came to her job interview wearing a headscarf. She was interviewed, she was eligible to be hired, and by all accounts was, if not the best, one of the best candidates they interviewed. So all else being equal, they would have hired her. She was eligible and that she could have been hired. Unfortunately, Abercrombie has a look policy that prohibits all caps, and that's in quotes. Doesn't I don't believe it explains or expands any more than that, just caps. So they interpret that to mean no headwear whatsoever. Basically, EEOC, Abercrombie hiring manager called his regional manager, who wasn't sure, called theirs. It's important to note that Ms. Eloff never actually requested a religious accommodation during her interview process. She just simply showed up as she was, wearing her headscarf, interviewed, and left. She never told them, I am a Muslim and I must wear this headscarf. They never got into that whatsoever. Abercrombie decided and that it believed that her headscarf would violate its look policy, and so they refused to hire her. Again, that belief, another word for that could be assumed, because they had no idea. They had never actually talked to Ms. Eloff. So the issue here is whether an employer can be liable under Title VII for refusing to hire an applicant or discharging an employee on a religious observance and practice where the employee didn't actually provide the employer with direct, explicit notice of the need for an accommodation. So that's a mouthful, but can the employer be held liable if the employee has not actually told them they need a religious accommodation? That's what it boils down to here.
It's pretty much our question for that one. So who thinks that Abercrombie can be held liable for that? Raise your hand. Okay. Who thinks not? Looks like we're about 90-10.
90-10?
Yeah.
Got to go with the 90 on this one.
Yeah.
Good job, guys. The court held that to prevail in a disparate treatment claim, a job applicant only needs to show that his or her need for an accommodation was a motivating factor in the employer's decision, not that the employer had knowledge of the need for the accommodation. So what it boils down to here is Abercrombie had no idea, no real knowledge, if Ms. Eloff even needed a religious accommodation. But what they did was decide not to hire her so they could avoid having to ever even approach the issue of giving her a religious accommodation. So her religious practice of wearing the headscarf was a motivating factor in their employment decision, or non-decision here, to not hire her.
Do you guys have any suggestions on what you think Abercrombie should have done? Anyone? If you were Abercrombie, what would you have done?
They should have asked because they saw her wearing the hijab or whatever.
Right.
So knowing that she was the top running candidate,
Right.
during the observation process, they should have asked.
Yeah, if you don't know what you don't know, right? I mean, maybe she was just wearing that for the day. I mean, but they don't know that. They made this assumption that, oh, she's going to wear that the whole time, right?
And I'm sorry, I'll get to you in 1 second. Let me ask you this, though. When do you think they should have asked? At what point?
Very important.
Probably when they investigated. That would have been I would have asked her up front.
Okay. Before you made a job offer?
I sure would.
Okay.
But I'm a very forward person. I think when they checked with the district manager and no one knew, someone should have made a call to the candidate.
Now, it's important to remember here, she was the most qualified. So
And the evidence was clear in the record. They testified. Abercrombie testified she was the most qualified.
they had objective criteria for their interview. Basically, I think it was something like 1 to 5 on scores evaluation. And if she wasn't the most qualified, she was one of, and she was certainly eligible to be hired, and they needed employees. So
Yeah, they were probably hiring a.
I think over here, and then we're
One question.
jump around. Yeah.
How would you explain that policy when you saw that person with that on?
That's a great question. And like I said, what Abercrombie did here was call up the chain of command, and no one really knew, and they decided, until they finally reached someone who said, oh, no, absolutely not, that the headscarf would violate our look policy, no caps are allowed. And that was it. That's where they ended. We had some questions over here.
I was just going to ask, aren't they in a box no matter what they do when they ask the question? I mean, isn't their policy going to come under scrutiny anyhow because of religious reasons?
But not necessarily. Now, what I would have done if I had been Abercrombie, if I have the most qualified or a very well qualified candidate, she meets all my criteria for hiring. I haven't talked to her. What you need to do is make her that conditional job offer. Then, just like we said over here, show her your policy. Say, this is our look policy. Can you comply with this? If she says she can't, then you can look at whether you can make a reasonable accommodation for her religious practice. Now that's what we don't want to get lost on, is we're not saying that they had to make this accommodation. You know, based on their specific business model, their branding, their, you know, all of the issues specific to them, they may not have actually had to make the accommodation. But the problem here, the trouble they got in, was they never even got that far, because they refused to hire her just so they could avoid having that conversation. So, because that was going to be the tough questions. Yeah.
Can you explain how they could have avoided making the accommodation? What could they have done that would have allowed her to continue to practice her faith and work there without violating the no tax policy?
Well, again, you know, I think on that one.
This is you speculating.
Oh no, sure. Yeah, that's yeah. Take this for what it's worth. You know, I think on that one, you're right. It's kind of a binary. Either she's wearing it or she's not. So at that point, I think they'd have to look at whether or not making the accommodation for her religious practice was reasonable given their business. Because again, religious accommodations fall under, it's not the exact same analysis, but it's that same standard of a reasonable accommodation. So an employer is not required to make an unreasonable. So really, it seems to me they would have had the two options of either make an exception for her in their policy, or tell her, no, I'm sorry, we're not going to be able to make that accommodation. You're going to not be allowed to wear that. But again, the problem here was they never got there. They refused to even hire her because they didn't want to get there, because they wanted to avoid this tough question. And now for that aspect, I do kind of feel for them, because I can see how you feel. They were in a no-win situation there, especially if they didn't feel that they could make the accommodation. But the problem was they assumed that she needed it. They never even knew that she actually needed it. It turns out she is actually a practicing Muslim and does wear the headscarf, but they didn't know that for sure.
Was the record clear that they would have hired her but for her wearing?
I don't know about that. I would have to go back, but
I think it is, but I don't know for sure. I'd have read it.
Because I would think that would be a critical, that they would have hired her but for that.
Well,
I think this is a place where they dodged a bullet this time, but in the end, they will lose, they will fall, interstate commerce, that whole thing. I think in the end, all stores like that are not going to be able to keep it out, even for branding.
that we'll have to see. Again, the key factor here was that her religious practice was a motivating factor in their refusal to hire her. So, you know, again, even if they had hired her or made her a conditional job offer, and then discussed the policy and determined that they couldn't make the accommodation, that they would have been in a much better situation than if they had blanket refused to hire her because they didn't want to have that conversation.
If they had not gone through this series of telephone calls and had just said no at the outset, and without saying it's not our look policy,
Just not hiring her.
that would have been because
They probably most likely would have been fine there.
qualified candidates. But because they made this affirmative, they made all these telephone calls, all these inquiries specifically about this issue, that is why.
Yeah,
Right.
yeah. And that's an
their-
important takeaway.
Their scoring
is-
system and
The important takeaway here is don't let someone's characteristic or protected class be a motivating factor in your employment decisions. Make your employment decisions based on objective criteria, work-related criteria. Yeah.
But isn't the real problem here is that they basically turn their back, they put their head in the sand, they close their eyes, they ignored the situation, and that's really where their downfall was.
Yeah.
absolutely.
They
Absolutely.
were scared of having that conversation my guess is they were scared of telling her, no, we can't accommodate
They
this.
didn't go high
But
enough up the food chain. That's the problem. They didn't go high enough up the corporate ladder to get to the right person who would be smart enough to make that decision.
Right. They should have went to corporate legal, right?
I was going to say, I hope they didn't
Instead
talk
of
to
going up the
corporate
chain
legal.
of command, they should have went to corporate legal.
Yeah.
Yeah, absolutely,
Yeah.
absolutely. So this is a pretty publicized case too. I mean, there's quite a bit of news on that case as well.
Yes,
so.
sir.
Can you guys talk a little bit about the pros and cons of scoring interviews numerically and what have you, versus just, taking notes and deciding subjectively?
I'll let Jason handle that as the HR director, but my point of view on this is whichever way you go, take notes and keep good notes, keep
Right.
good documentation.
And if you choose to score candidates, you make sure you only score on job-related factors, okay, on their predicted performance or their past performance as far as job-related things. You don't want to score on things that are outside of that or anything of that nature. So, but whatever you do, as Justin said, you want to document. You want to document why you made the decisions, and if you're using a scoring sheet, you want to make sure your scoring sheet. I'd suggest you have legal look at your scoring sheet as well, to make sure that you're scoring the correct characteristics for the essential functions of the position. Okay.
Yeah, I think that's key, is focusing on what are the essential functions and the job-related aspects of objective scoring.
It's a good question, really good question. In my mind, in this Abercrombie thing too, I think Abercrombie, I can see them kind of getting caught up in the, hey, we have a look policy. We have a look policy. We can't violate the look policy, just like UPS, right? We have a light duty policy. We can't go around our policy. So you need to be careful in your organizations about policies like that. You need to kind of open your mind and make sure you look at them, make sure you look at all the facts.
Like I said, I hope they didn't
Yep.
that escalate. I hope that didn't escalate all the way to their legal counsel with that advice. But staying on religious discrimination, this one's going to be a little easier, a little less controversial, I think. The issue here is the job applicant filed a complaint against the employer for religious discrimination for their failure to accommodate him because they refused to hire them because he refused to give them his Social Security number. He said his religion prohibited him being labeled with a number, so he disavowed his Social Security number and refused to give it to the employer. And so when they didn't get the complete paperwork, they didn't hire him. So then the question is, the issue, whether the applicant stated a viable claim for religious discrimination under Title VII.
So what do you guys think? Do you
thoughts
think
on this one?
No.
Right.
Yeah, that was pretty easy, right?
Yeah.
I mean, I think that was a cupcake. If I were giving out chocolate, I would be out of chocolate at this point, because that was a cupcake. That really was.
Everyone give yourselves an imaginary point here. Good job. I will note on this one, you'll see this is the only Sixth Circuit case we talked about, we're going to discuss today. This is not a U.S. Supreme Court decision. This was from the Sixth Circuit, which is our circuit here in Kentucky and Tennessee, Michigan, Ohio. But I would note that I don't believe every other circuit has addressed this type of question, but every circuit that has addressed it has held the exact same way. The issue here, of course, is that the IRS requires employers to provide Social Security numbers for their employees. So the court held that an employer is not liable for religious discrimination when making an accommodation would require them to violate federal law. So that's what would have to happen here. They would have to violate the IRS rules and regulations in order to make this accommodation to just allow this person to exist with a name and no Social Security number. So,
Right.
So that one's a pretty easy one.
Yep. We're going to switch gears now with same-sex marriage and FMLA. How many of you guys provide FMLA benefits to same-sex marriages?
Oh, wow.
Hey, great. That's right. We did before.
Before June 26th.
Before, yeah. How many did it before June 26th?
Great.
Okay. Good.
The rest of you guys, get ready. You need to start when you get back, reviewing your policies. We're going to discuss here, first we're going to briefly discuss US v. Windsor, which dealt with DOMA, the Defense of Marriage Act, which, the federal DOMA, because many states have their own version of DOMA that's state law only. So Windsor dealt with DOMA. Then we're going to briefly discuss, just to give you an outline where we're going here, the Department of Labor's final rules on FMLA with regards to same-sex partners or spouses. And then we're going to briefly discuss Obergefell and where we are now. So US v. Windsor, short of it, the Supreme Court struck down Section 3 of the Defense of Marriage Act, held that DOMA violated the Equal Protection Clause of the Fifth Amendment's Due Process Clause, Equal Protection Component, excuse me. Basically, the court held that defining spouse to exclude a same-sex spouse under federal law is unconstitutional. So did not address state DOMA laws, Windsor, but basically struck down the federal DOMA definition of spouse as being between a man and a female only. And so after that, the Department of Labor, who is responsible for enforcing FMLA, sorry, take a step back. Everyone familiar with FMLA? Everyone, we're on the same page? Good, good. The Department of Labor, who's responsible for enforcing FMLA, went back to the drawing board and wrote up new rules for FMLA. And basically what the final rule is going to do is allow all legally married same-sex couples to engage or to have to the right of FMLA protection, job protections. What the Department of Labor did with these final rules, they changed the criteria from a state of residence, so whether or not the couple was married in the state where they reside, to the state to a place of celebration rule. So if a couple, same-sex couple, was married in a state where same-sex marriage was legal, then regardless of where they lived after that, they were entitled to FMLA job protection. So that's the Department of Labor's final rules on that. They were, I believe, went for public comment in, let's see. Oh, they were finalized, excuse me, on February 25th of 2015, and they were supposed to go into effect on March 27th of 2015, so a few months ago. The day before, March 26th, there was litigation filed in Texas, Texas v. U.S., the state of Texas, suing the Department of Labor, basically. So those rules were put on hold. So everyone was ramping up, ready for extending FMLA to legally married same-sex couples, and then there was a hold. So that was in March. So
I built that slide. Nice.
This is quality content, folks.
Yeah. Make sure they get a shot of that with the camera. I hope they get that recorded. That's really worthy, that slide was. So.
But as we all know, so that was on hold, and everyone was thinking, well, it might be, you know how litigation goes. It might be years. Who knows when we'll see what the Department of Labor's rules on FMLA are going to be. Then we had Obergefell. As you all know, everyone's aware of this case, I assume. Everyone's nodding their heads, yes. It was 14 same-sex couples and 2 men whose same-sex partners had deceased, filed suits alleging that their states had violated the 14th Amendment by refusing to issue them marriage licenses and by refusing to recognize their marriages that were legally performed in another state. So those are basically the 2 issues here. Whether states must issue marriage licenses to any 2 people, and whether states must recognize same-sex marriages performed legally performed in another state. So everyone's aware of the outcome on this one.
I'm not sure I can even ask them that one.
Yeah,
I think I'm not going to insult them on that one. I'm pretty sure they know the answer is yes and yes. So yeah, we're not going to go there.
Yes and yes. Court held the due process and the equal protection clauses of the 14th Amendment require states to both issue marriage licenses to same-sex partners and to recognize legally performed same-sex marriages in other jurisdictions. Basically, the court held that marriage between 2 people, and again, that's an important distinction. The court specifically said marriage between 2 people. So there shouldn't be, I wouldn't anticipate an extension of this precedent into something like bigamy. But the court was very clear, but saying that marriage between 2 people is a fundamental right, and that same-sex partners should have the right to be issued a marriage license or have their marriage recognized. So that's Obergefell. That seems easy enough, but there's a lot of changes that are going to be coming, waves of changes that are going to be necessary coming after this. So back to FMLA. Texas v. U.S. is still technically pending. That hasn't been dismissed to my knowledge. Now, if something happened this past week while we were here, then be happy to know. But to my knowledge, it's still pending. But it's almost certain that Obergefell is going to result in FMLA cut protection being extended to same-sex married couples. So get ready for that. So those of you who maybe haven't reviewed your FMLA policies in a while, now would be the time to dust those off. And for this group as well, it's probably starting time to look at your forms and form pleadings. So dissolutions, adoptions, all of those types of things, probably going to want to dust those off and take a look at.
For the HR folks in the room, you're probably going to want to look at your bereavement policies, your sick policies, benefits, those type things. You probably want to take a look at those as well.
Yeah, and any of you HR guys are probably going to have a lot of qualifying life events coming up of marriages that are going to entitle them to reopen their enrollment for health insurance, those kind of things. So these are all the things that you should be thinking about now, because it's here. It's here now. So let's see. Forgive me. Okay, so we said the Supreme Court held that marriage between two people is a fundamental right. Now, what they did not hold was that LGBT employees are a protected class. So a Obergefell decision did not address or discuss Title VII of the Civil Rights Act whatsoever. By labeling marriage as a fundamental right, the court was able to not discuss protected classes whatsoever. So as you probably know, courts have historically rejected Title VII claims on the basis of sexual orientation. So LGBT employees who have tried to sue under Title VII claiming sex discrimination, for the most part, those claims have failed. Courts have traditionally held that sex discrimination means biological sex and doesn't relate to sexual orientation. But I will tell you, this is the forefront. This is where, and we'll talk about when we get to the EEOC Strategic Enforcement Plan, the EEOC strongly and firmly believes that sexual orientation should be encompassed within the term sex discrimination under Title VII. So that is what the EEOC is trying to push the ball forward on. They are trying to include sexual orientation under sex discrimination within Title VII. Hasn't happened yet, but you should be aware that in the years, and now, who knows? I wouldn't even guess, if ever, when that would happen. But as we'll discuss, the EEOC has filed 2 transgender suits against private employers so far under the label of sex discrimination. So they are taking an active role in this. We'll note, just because we missed it, while sexual orientation has not been held to fall under sex discrimination in Title VII, there have been 2 important cases that expanded that definition or the scope of sex discrimination. One was Price Waterhouse v. Hopkins. That case involved a female employee, I believe it was Price Waterhouse Cooper, the accounting firm in New York, a female employee who didn't dress stereotypically feminine, in a feminine manner. She was called into her boss's office. He told her, he said, you know, you'd probably go farther and go farther faster if you just wear a dress or some makeup every once in a while. Those kind of things.
Whoops.
So, whoops is correct. As you
Wow.
can guess,
Wow.
as you can guess, the court didn't look too kindly on her employer in that situation, and basically, or held that sex stereotyping is a form of sex discrimination under Title VII. So that's sex stereotyping. The other important case was, I believe it's Oncal v. Sundown Offshore Oil Services, ruled that same-sex sexual harassment can occur. It is a legally viable claim. So, and that extends as far as one straight male can sexually harass another straight male. Same for females. It doesn't matter sexual orientation. Anyone can basically sexually harass anyone else. So
if you get a best practice there, if you get a claim, investigate it just as you would
Yeah.
any other claim. You need to go about your processes in regards to investigating, getting the facts, and then making a determination.
Yeah, the worst thing you could assume was, oh, I know Jim. He has a family and 3 kids. He would never do that to Mike. You know, I mean, so investigate and keep documentation.
Yep.
One thing you do want to be aware of in the scope, the area, are the local ordinances, the municipalities. Now, I don't vouch for these numbers as being, like I said, accurate as of right now, because this is highly evolving. This is changing by the week. But at least 185 cities and counties prohibit discrimination based on sexual orientation or gender identity. Then he also banned marital status discrimination. It's rapidly changing. You need to be aware of is you need to know if you have a local ordinance, a local fairness ordinance, a local anti-discrimination ordinance. You need to know, and if you do, you need to know what that says, because that's going to apply to you if you have an operation in that municipality or county. So be aware. These are actively evolving. This is something that's happened at the ground level, and then, like I said, the EEOC is trying to push it down from the federal level. Talk about the Employment Non-Discrimination Act. Now, don't worry, this has not been passed. Or no, don't worry, but don't worry if you haven't heard of it, because it's not been passed. But every year since 1994, except one, it's been introduced in Congress. And basically, it would ban hiring and employment discrimination based on sexual orientation or sexual identity. And it would apply to civilian, non-religious employers with at least 15 employees. So probably everyone here, is my guess. Hasn't passed yet, like I said, but with what's happening with the Burgerfell, it wouldn't surprise me if it had a little more traction next time it came up.
Also, in regards to the LGBT community, I think for employers, there's several emerging questions, such as restrooms. Restroom scenarios. Are they going to be unisex, gender neutral, restroom of choice, or how are we going to handle that as an employer? I mean, that's a big concern. A lot of question marks there for employers. Also, dress codes. To what degree can you enforce the dress codes, things of that nature.
And remember Price Waterhouse, sex stereotyping.
Yep. And then also a bigger question, I think, is perceived customer bias. I mean, what if your customers aren't treating your employees well? I mean, that's going to be also an emerging issue. So I think best practices when it comes to LGBT employees is be aware and comply of all your applicable state and local non-discriminatory laws and ordinances. So you want to know if you have any organizations that have those local ordinances are located where the local ordinances have been passed. You want to ensure all your employment decisions are based solely on merit and non-discriminatory perceived notions of gender stereotypes. It's kind of the golden rule in HR, right? You want to make the decisions based on job-related necessities or job-related things. You want to ensure your policies comply with state and local laws, and you want to train your employees on policies and place appropriate emphasis on kind of building an inclusionary culture is probably going to be your best approach. I think that, as leaders of organizations, I think that's going to be your best approach for your organization is to develop an inclusionary type stance.
This is where we're going. This is where we are now, and it's going forward. So my advice as an attorney is, regardless of your religious, political views, or those of your, and I'm not saying you, those of your supervisors, those of your ground people, just like Jason said, you're only going to be asking for trouble if you don't focus on trying to create an inclusionary environment in your work. Focus on the work is the key. Don't focus on people's personal lives or their sexual orientation, their identity. Are they a good deputy clerk? Are they a good court administrator? If not, why not? What are the work-related, objective work-related reasons not? And as with everything, keep good documentation. Put that on, chisel that in stone for all of it. Keep good documentation.
Before we move on, are there any questions about same-sex marriage or LGBT questions? It's obviously a big topic. How many of you guys watched the ESPYs last night and saw? Yeah, it's obviously a big topic.
California already has the Fair Employment and Housing Act, which includes gender expression and gender identity, and employees can use the restroom that matches with their gender
identification.
Right.
Mm-hmm.
Interesting.
That's one of the things we discussed when we were presenting, some emerging questions. We realized we can't really give good advice because we don't know what your guys' facilities physically look like, because that's what you actually have available is also going to make a determination of what you can make your policy, what you can offer to your employees. But again, it's key that you start thinking about these things.
I think, though, that's good guidance on the gender identification and expression issue, because that's where that's going to go. I know
Sure.
in our General Assembly in Kentucky, there was a bill that was proposed that would prohibit that in high schools. And that was actually beaten back on exactly that issue, and I don't think we'll ever see that bill again, that would prohibit
there was some powerful testimony at the committee level from a transgender teen. He spoke very eloquently about the issue. So, as Lori said, that didn't pass, and don't anticipate that to come back.
How long in California has that been? Do you know? 2000. Did you guys have a lot of growing pains with that from 2012 forward? I mean, did you have non-LGBT employees complain about that or anything of that nature? I'm curious.
We have not seen it.
Okay.
But like for instance, at my facility, all of our restrooms are individual, and so they're all,
Yeah.
you know, whoever can use them type of a thing. And we have so many different types of people that come into our main
Right.
downtown LA building.
Sure.
That honestly, you can't really make any type of assumption.
Right.
Sure.
Interesting.
Got your stall, I got mine. We're gonna go
Right.
over
I certainly agree with Laurie's
Right.
comment. I think it's a best practice, though, to kind of go forward because I think it's going to be on the other states soon. And I think, you know, having California in that position since 2012 is probably a good thing for those that aren't in California to probably look at doing if you have to.
We have had some issues with our sheriffs or our bailiffs, and so we've had some issues with them making reference to some of our transgender employees. So those are to be dealt with.
Yeah. Okay, great. Thank you.
Okay, we're definitely going to be switching gears here, talking about the NLRB a little bit.
So if you're not asleep yet,
yeah,
you may
yeah.
be asleep now.
And I've already given this caveat once, but I will do it again to the full group. Jason and I work here in Kentucky. We do not have union employees. I do not pretend to be a labor law expert. But this is some emerging issues from the NLRB, who everyone knows the NLRB. How many of you guys actually have union employees? So a few. NLRB is a 5-member board appointed by the president, and their function is to enforce the National Labor Relations Act. National Labor Relations Act covers all employers engaged in interstate commerce above specified minimal standards, and it applies equally to union and non-union employers. So even if you don't have union employees and you meet the minimum standards otherwise, the NLRA applies to you as an employer. So basically, what we're going to talk about here is the NLRB weighing in and making some decisions on employee handbooks and employee confidentiality policies and social media policies for employees. As we discussed before we got started, NLRB is one of the first organizations that's trying to wrangle with social media. They have a clear opinion on what employers can and can't prohibit. So we're going to discuss that a little bit here. Basically, the National Labor Relations Act protects employees' right to engage in concerted activities for the purposes of collective bargaining or other mutual aid or protection, as well as the right to refrain from such activities. These rights include self-organization, form, join, assist labor unions, bargain collectively, these kind of things, concerted activities. So how does the NLRA and how is the NLRB weighing in on social media and employee handbooks? Basically, it's the NLRB's position that personnel policies may restrict or have a chilling effect on employees' rights to undertake concerted activities. So what we're talking about here are policies that prohibit employees from speaking or writing or posting on social media about information about wages, complaining about their policies, complaining about their work, complaining about their managers, displaying union logos or paraphernalia, expressing union support, attempting to unionize, and discussing employment terms. So those are all protected concerted activities. So the NLRB is weighing in on overly broad, to their interpretation, overly broad employment policies or personnel policies that may infringe or have a chilling effect on the employees' rights to those activities. So on March 18th of this year, the NLRB General Counsel issued a memorandum entitled Report of the General Counsel Concerning Employer Rules. So very specific, right? Now, just a note, the General Counsel's memorandum, the General Counsel of the NLRB has the ability to make public his memorandums when he sees fit. They're not law per se; they're his interpretation of the NLRA as it affects the enforcement of the NLRB. Basically, they're publicized to make their policy goals or their policy aims known public. So that's where we're going here. But basically, the General Counsel's memorandum said that even though a rule may not explicitly prohibit Section 7 activity, it can still be found unlawful if employees would reasonably construe it to prohibit concerted activity. The rule is actually promulgated or made in response to protected concerted activity, or the rule is applied in a manner that restricts or prohibits concerted activities. So what they're looking for, basically, to decode that, is overly broad policies that prohibit you from talking about your work. They're looking for overly broad confidentiality policies that prohibit you from a confidentiality policy that would say you can't speak about your employer whatsoever. Well, no, the right to complain about your employer and about your employment is considered protected Section 7 activity under the NLRA. So they're looking to restrict those overly broad personnel policies. Let's see. They gave some examples of lawful confidentiality policies.
We put those in your binder too, so you guys are in your resources. So when you get back home and you look up the big 72 slide thing, it's all in there as well.
Yeah.
So.
Basically, no unauthorized disclosure of business secrets or other confidential information. That was found to be lawful. Misuse or other unauthorized disclosure of confidential information not otherwise available to firms outside the employer is cause for disciplinary action, including termination. That was found to be lawful. Do not disclose confidential financial data or other non-public proprietary company information. Do not share confidential information regarding business partners, vendors, or customers. So you see, those are restricted. Those are narrowly tailored confidentiality policies to the work. I think where employers are getting in trouble is when they're trying to restrict what the employee can say about themselves or about their fellow employees or about their managers. That's a tough one. The NLRB's position is that employees have a right, including on social media, to specifically complain about their managers. My boss is an idiot. He's a jerk. He's terrible. According to the NLRB, their view, that is protected Section 7 concerted activity, and employers can't prohibit that. Yes?
It seems like I'm from Ohio, and I've seen some cases where when you throw the elected official element in, you kind of tip the hand like, okay, now you stepped over the boundary. When you said this elected official is corrupt or whatever like that, even though there's no basis, that this can be dealt with. Are you seeing that?
That's interesting, especially for this group, because I know we have a policy that requires employees to conduct their personal and professional affairs in a manner so as to promote public confidence in Kentucky's judicial system. I think what you're going to find is that states do have a compelling interest in promoting the public confidence in the judicial system that needs to be. We need to promote the appearance of being objective and not having improprieties. So again, I wanted to discuss these, but with this group, and again, it's the NLRB who, frankly, they're struggling to remain relevant in today. Labor unions are, as we all know, decreasing dramatically or have been decreasing. This is the NLRB's grasp at staying relevant. They found social media policies that were overly broad, and they've latched on. So how worried am I about our policies? Not at all worried. I'll tell you that.
Well, we have successfully enforced our policies with respect to disparaging comments like that about supervisors or judges or anybody else on any form of social media.
Unfortunately, social media is the new bathroom wall. you know, I mean, you know, it seems to be, or it can be. So you've really got to, you know, when you have your policies, you've got to write them in a way in which that you can address issues that need to be addressed. You know, and then also you get calls, and I don't know if I should really say this, but you get, you sure? Okay. You get a call from an elected official that says, Jason, I'm going to join this Facebook thing, and I want to, can I make my employees friend me so I can see what they're saying? I'm like,
I got that call, and I took a few moments.
Yeah, kind of set you back a little bit.
Deep breaths in, deep breaths out.
Okay, let's try to address this one, right?
Yeah.
So have you guys got any of those calls? You're in HR? No, not yet. But I'm glad they called, right?
Yeah.
Instead of doing it and then saying, hey, you know, you must join. You must friend me. You know, so kind of interesting. But.
Yeah. Let's see. So. Oh, I see. So NLRB did, in the General Counsel memo, provide an example of a lawful policy that would prohibit what the employee could say respond about the company. And basically the NLRB's line is that policies that tell employees that they don't have the right to respond on behalf of the company, to act as a company spokesman unless that's actually their job, those are lawful. Those are completely lawful. So you can have policies that say, no, you can't talk to the media. We have a public relations officer who's going to handle that. But what you can't do is prohibit them from talking about themselves. So they can't represent the company or purport to represent the company or the organization, but they can speak from their perspective. Again, protected Title VII concerted activities here.
Examples would be, you know, our benefits are terrible, or I hate our working hours, or I hate working Saturdays, or do you hate working Saturdays too? I mean, those type things are all concerted protected activity.
Yeah, and going right along with those examples, we do have an example. It's the 3D. It's an NLRB case. Basically, the NLRB unanimously found that the employer violated the NLRA by discharging 2 employees for protected concerted participation in a Facebook discussion where they were complaining about their perceived errors in the way their employer withheld taxes. So they were complaining about their employer's tax withholding calculations on Facebook. Employer fired them for that. NLRB found that was in violation of the NLRA because that was concerted protected activity. So. Any questions about this area?
This subject, or
you know, again,
NLRB?
Don't pretend to be an expert here, but this is something new. You know, the General Counsel memo came out recently, so you might want to take a look at that. It can be found on the NLRB's website. At least read the executive summary to get an idea of what they're looking for. Basically, overly broad policies. Anything? All right.
Moving on.
Do we have till 11:30? We have 15 minutes.
Yep.
Okay, we'll power through here. I think we're going to be able to finish. We wanted to talk about the EEOC's Strategic Enforcement Plan, fiscal year 2013 to 2016. So we're still right in the middle of that. But like we said earlier, even after fiscal year 2016, I highly doubt the EEOC is going to chuck all of these in the trash can and move on to something completely different. These are still going to be important to them. But the takeaway right now is that these issues are the national priorities for the EEOC. Now, EEOC does have regional priorities, so I would encourage you to go to the EEOC website and see what their regional priorities for your area, your geographic area are, because they're going to be focusing and tailoring the national priorities to each specific area. But these are national. These are what they're looking for. These are the types of charges that they want to get from employees. They are welcoming these types of charges from employees, and when they get them, they're going to be much more likely to actually investigate these types of charges as opposed to simply issuing the right to sue letter and moving on. So starting out, eliminating barriers in recruitment and hiring. What they're looking for here are exclusionary policies and practices, so that keep one protected class out, one gender out, one race, one ethnicity. Restrictive application processes, restrictive screening tools. such as criminal history checks, pre-employment medical exams. They're looking sternly at these types of things. And steering. So steering particular groups or classes into particular types of jobs. So if you go and every single secretary and paralegal is a female, and all of the the deputy clerks are males or whatever, they're looking at those for those types of issues. So with regards to screening, as far as criminal history checks, EEOC is focused, and like Jason said earlier, this is a term we've used throughout the day. They're focused on promoting employers to do individualized assessments for job candidates or employees with criminal histories. So what they're trying to get away from, what they're trying to push, is employers not to automatically exclude candidates or employees simply based on criminal history. And so what do they want with that? They want an individualized assessment. What they mean by that, they want employers to give the employee the opportunity to explain it. Let them explain that was 20 years ago. I haven't had a criminal charge or a conviction since. I've reformed my life. It wasn't even related to this. I'm applying for an accounting position. I got a DUI 10 years ago. They want you to allow the employee to explain their position. Then they want the employer to review and look at those factors, such as the time that's passed, the seriousness of the conduct and the offense, and then look at it in relation to the nature of the job held. So if you're hiring for an accounting position and you have a candidate who 2 years ago was convicted of embezzlement, maybe that's going to be one of those where it's okay to go ahead and not pursue that candidate any further. But if you have that same accounting position, and like we said, 10 years ago they got a DUI, what the EEOC is looking for is that you're not automatically excluding them. Or even something simpler, take it back from DUI, a PI, a public intoxication, those kind of things. What they're looking for is not automatic exclusions based on that criminal history. And they're really expecting and asking employers to weigh the seriousness and the time that's passed and the other factors before they make an exclusionary decision. Yeah.
Are they suggesting that you have to do that inquiry regardless, whether you would exclude or not? So if I get a criminal history that was a DUI 20 years ago and I say, let's not even worry about that.
Oh no! If you're not going to worry about it, what they're looking for only if
That's
you're
what they
going
want.
to exclude it. Yeah.
That's what they want.
Yeah,
they want you to do that. They want you to say,
if your
kind of ban the
your
box type
organization
stuff.
recognizes that no one is perfect and people unfortunately have histories that may not be stellar, but can look past that and move on, then no, you're not going to need to. If it's not a problem for you, it's not a problem for them.
If you're going to do background checks, you need to do them consistently, equally, and fairly.
Do
You
them
don't want
fairly.
to arbitrarily do a background check. You should probably have a policy on background checks, and then you need to do them do it consistency. You don't want to only background check, say, female applicants, or only background check people from Louisville instead of Lexington. Those type things. So you want to make sure.
We're not a protected class yet, but maybe we'll get there.
Yeah, you may be. I don't know. And again, kind of just to echo what Justin says, you don't want to automatically exclude candidates. You just want to be careful and try to, if you things do come up on that.
I'm sorry. Or if you are going to automatically exclude, make sure that it's based on an objective job-related criteria. So, like the accountant embezzlement example, that's a very clear job-related criminal offense that goes right to the heart of the position. Like we said, the public intoxication or the citation for public drunkenness, is that really going to be so those are the things that they're asking employers to look for. Any more questions on those? Oh, one other thing as far as screening, don't ask medical questions before a conditional job offer is made. So don't start. So how's your health? Can you
Hey, you had a limp. Is your leg okay?
Yeah. Don't do that.
Yeah, it's not a good sign.
2, we're not going to discuss much here. Hopefully everyone's doing this, but just want you to be aware. One of their national priorities is protecting immigrant, migrant, and other vulnerable workers. So the things they're looking for are disparate pay, job segregation, like we talked about. If you look at the warehouse, and the warehouse is all one ethnicity or one race, but all the office workers are Caucasian Americans. They're looking for those types of issues. Harassment for, again, vulnerable or workers or immigrant or migrant workers, and human trafficking. So you may have heard the story, I believe, the New York Times, regarding nail salons in New York City. Anyone hear about that? Seemed like basically they were indentured servants, the workers in the nail salons. So EEOC is looking for those types of issues, and they want to get those types of charges. Let's see, we're running short, so I'm going to try to move forward here. Number 3, addressing emerging issues and developing issues. We've talked about this one. This is, like we were saying, the EEOC is pushing for sexual orientation and sexual identity to be included under sex discrimination within Title VII. EEOC is rolling the ball forward on that. They've filed 2 lawsuits in 2014 on behalf of transgender employees against private employers. And then they recently filed an amicus brief in the 7th Circuit arguing that sexual orientation is unlawful sex discrimination. So they're pushing that forward. They are moving that. Number 4, enforcing equal pay laws. They're focused on compensation systems and practices that discriminate based on gender. So they're trying to address the pay gap issue that we unfortunately still have in this country. So
two takeaways on that one. One, you need to have your pay practices or your pay plan established. You need to follow your plan and your practices. And then 2, you need to document why people are getting raises and the reason behind that raise as a job-related factor. So those are kind of 2 takeaways on enforcing equal pay.
Number 5, preserving access to the legal system. Really what they're looking for here, and I doubt many of us as court employees, representatives of court organizations, have severance packages, but they're looking for severance packages or policies that restrict or prohibit employees from taking protected actions, such as filing EEOC charges. So a lot of private employers are having severance packages when they're doing reduction in force, saying you accept this $50,000 and you will not file an EEOC charge of racial or gender discrimination against us. No employer can prohibit an employee from filing a charge. Employers can make agreements with employees that the employee won't accept any financial benefit from filing that charge. So if there's an award of damages, the employee will not accept it or will not get it personally. But you cannot prohibit an employee from being able to go to the EEOC filing a charge. Let's see. Oh, they're also putting, in 5 here, they're putting a heavy focus on retaliation claims. So they're wanting to get employees coming to them with charges of retaliation. So, I complained that my supervisor was sexually harassing me and then they fired me 2 days later. They're looking for those types of retaliation claims. They want them. Number 6, preventing harassment through systemic enforcement and targeted outreach. Does everyone know what a systemic investigation is? Anyone? These are basically, you have the single charge. So an employee comes and said, I was sexually harassed by my boss yesterday. The systemic is, as an organization, either their policies, their corporate culture, or their practices, everyone is, so it's more widespread. Everyone is sexually harassing subordinate female employees, or whatever the case may be. So they're looking for those. The way they get those systemic investigations is either an individual charge comes in and alleges a class allegation. So every single person of my ethnicity in my company is discriminated against, or that kind of thing. Or if the charge doesn't include a class allegation, upon investigation, if they find evidence that there's a larger problem, they can go ahead and expand the scope of their investigation on their own without the allegation even being a class allegation.
I think you'll see that a lot, like if you have an investigation on a charge or you receive a charge and the investigation's in process. I think you'll see the EEOC request data that's broader than probably what you think they should, or that they'll start looking more systemic in their investigation efforts so that they can meet their goals.
That's what they're looking for. They're looking for pattern of practice or facially discriminatory policies. So what you need to do here is be proactive and keep your finger on the pulse of your organizational culture. Make sure you're training your supervisors and you're refreshing that training for your supervisors. Let's see.
We've got 4 minutes and one slide.
4 minutes and one slide, the ADAAA. Like I said earlier, this is the Americans with Disability Amendment Act. Became effective January 1st, 2009, so several years ago. So why are we talking about it on July 15th, whatever today is, in 2015? Because frankly, a lot of people haven't done anything with their ADA policies yet. And so even still. And so this is just a general reminder that if you haven't reviewed and updated your ADA policy since 2009, now is the time to do so. Short of it, I know we're running out of time. ADAAA basically significantly and purposefully expanded the definition of disability. It expanded the definition of major life activities, which goes into the definition of what a disability is. And it also included major bodily functions as being included in major life activities. So what the purpose of that was is Congress was trying to capture a lot of disabilities or a lot of ailments that had previously, because of case law, had been specifically carved out of ADA coverage. So things like cancer, things like diabetes, things like epilepsy, before the ADAAA, they were not considered disabilities under the old ADA, and so employees had no rights to reasonable accommodations if they were afflicted with those impairments. So that's the purpose. The takeaway that I want to get to you is the whole purpose of the ADAAA was for Congress to tell employers and courts that employers shouldn't be haggling or arguing with their employees about whether or not they have a disability. They've significantly expanded the definition of disability to include a lot of things that weren't included. Where you need to spend your time as an employer is in the interactive process. Speaking to the employee, speaking to the employee's doctor, through your forms with regards to the essential functions of their job, making the determination of, can we make a reasonable accommodation for this employee's disability? If so, what should it be? They want you to focus on the interactive process. Courts have been directed by the ADAAA to focus on whether discrimination occurred or failure to accommodate occurred, not on whether the person was disabled. So that was a directive to the courts. The takeaway for employers is don't waste your time on the front end, engage in the interactive process, update your forms.
Yeah, that's essentially what it is. Guys, that's all we have. We've got about a minute left, but we'll stay if you have questions. You guys have been a great audience, and thanks for staying awake and hanging in there for the last concurrent session. I hope you've enjoyed what you've seen today, and we appreciate you attending. So,
thank you all.